Oh, well, hello. My name is Stephen Todd, and I am an academic lawyer. My key research interests are in the field of the law of torts. This concerns the infinite kinds of ways in which one person may be held liable to another for causing harm to that other. So I'd like to bring up my first slide, which just says that. So here we are. The law of torts is concerned with those situations where the conduct of one person causes harm to or invades the interests of another. It is the body of the rules that determines whether or in what circumstances that person is liable to pay compensation to the injured party. Now, a simple example is a driver negligently causing a road accident. In New Zealand, a claim for compensation in respect of personal injury is covered by the accident compensation scheme, and no claim for damages will lie. But there may be an action in respect of the damaged property in that particular case. But more broadly, for all kinds of loss other than personal injury covered by the accident compensation scheme, the law of torts governs the question whether a victim has a claim for damages against a wrongdoer. Tort is therefore a vast and sprawling area of law, and certainly it is of very considerable interest. And it throws up new problems and new questions all the time. So what I'm going to do now is just tell you about three such new and very different questions that have arisen recently before the courts in New Zealand and elsewhere. Right, well, the first one concerns climate change. A case currently before the New Zealand courts was brought by an elder of Ngā Puhi and Ngāti Kahu against Fonterra and 6 other New Zealand companies, alleging that their operations were contributing to global warming. And this, it was argued, posed a risk to food and water, it posed a risk to their land, and it posed various other adverse consequences. Now, this claim went to the Court of Appeal, where the court struck out the claim, saying it could not come within any principle of tort allowing recovery. And that brings me to my next PowerPoint. And this is a case, Smith and Fonterra, decided just last year, where, as you can see, the court said that the inability to join to the proceedings all material contributors is an insuperable problem. It can only be overcome by the court agreeing to abolish the relational underpinnings that are fundamental to tort law. In fact, the court then went on to point out various associated problems. It said, well, recognition of a duty would create a limitless class of potential plaintiffs, as well as a limitless class of potential defendants. Defendants would be subjected to indeterminate liability and embroiled in litigation and highly problematic and complex contribution arguments on an unprecedented scale. So contribution arguments are arguments between potential defendants. So there we are. They said this claim couldn't proceed. Now, in my view, that's quite right. The core problem lies in showing any kind of connection between the defendants and the plaintiff, and also showing that anything done by Fonterra or by the other defendants was actually a cause of the alleged damage. Now, legal issues posed by global warming may be tackled at the government level as matters of public law, and also by the criminal law, but not, I think, by the law governing private disputes alleging one person has caused damage to another. Now, having said that, the New Zealand Supreme Court, New Zealand's highest court, has granted leave to appeal to the plaintiff. It did that just a week or two ago. So we will see what New Zealand's highest court makes of this question in due course. Right, well, that's my first example. The second one concerns an in vitro fertilization procedures. Now, a number of cases concerning negligently performed IVF procedures are being litigated around the world. And these pose entirely novel questions of law. In one leading decision, it is in fact a case from Singapore, A husband and wife sued a fertility body after it turned out that that body had not used the husband's sperm, but that of an unknown man. So the consequence of this was that a child was born who was unrelated to the putative father. So what exactly had the couple lost here? Whatever it was, and how could it be quantified? Now, the answer given by the court was a loss of genetic affinity, which is a completely new head of claim, and the court quantified it as 30% of the cost of bringing up the child. Right, so we can see that in my next slide. This is the case ACB and Thompson Medical, where the court said that the appellant's loss could not be understood without a more developed and substantive, as well as nuanced, notion of autonomy that took into account existing family building practices, kinship arrangements, and the socially constituted value of genetic relatedness. The true loss which she had suffered in this case, which could and should be considered a distinct and recognizable head of damage, was a loss of genetic affinity. Now, this had never been decided before in any court. Now, I do in fact agree with the result in that particular case. But in my view, the claim should be more broadly based on what I would call a loss of reproductive autonomy. And the damages should be quantified in a way which seeks to measure that particular kind of loss. It seems to be that 30% of the cost of the bringing up the child doesn't do that, and I think it can be done. So I would agree generally, but I would put it on rather different bases. Now, many other claims against fertility bodies involving both parents and children are being brought around the world. For example, and quite remarkably, actions are being brought in the Netherlands and in Canada, where in both of these claims, the director of an IVF provider allegedly used his own sperm to fertilize the eggs of that provider's clients. In the Netherlands case, it's been determined that the director was the father of at least 49 children. In the Canadian case, there are 150 claimants. So those claims are in fact ongoing. Now, in another case in the United States, the IVF provider's mistake in implanting the wrong embryos resulted in the woman receiving the IVF treatment giving birth to twin boys who were unrelated to the plaintiff couple or to each other. And further, amazingly, the couple were obliged to relinquish custody of both boys to their different genetic parents. And the clinic had not actually advised the claimants what exactly had happened to their own embryos. And more such claims are certain. They involve advancing fertility technologies and certainly unique forms of damage, because the damage here is founded upon both the existence and the characteristics of a human being. And as always, the common law has to develop and has to adapt in accommodating such new claims. And that's my second example. The third one I'll give you concerns biosecurity breaches. Now, a recent case decided in the New Zealand Court of Appeal has obvious resonance in these days of the COVID-19 pandemic. Now, what happened here was that a large number of owners of kiwi fruit orchards sued the Ministry of Agriculture and Fisheries for negligently granting a permit for the import into New Zealand of a consignment of kiwi fruit pollen from China. And they did this without undertaking a necessary risk assessment of the pollen. The consignment introduced the PSA3 bacterium, which causes bacterial canker of kiwi fruit. And this disease swept through the kiwi fruit orchards in the Bay of Plenty region, and it certainly decimated the whole industry. The plaintiff's losses might have been as much as $450 million those of kiwi fruit growers generally had been calculated at $2.4 billion. The claim failed in the Court of Appeal, primarily because of the huge implications of allowing it. So again, we move to the next slide, and this is the case, Attorney General and Strathboss Kiwi Fruit Limited. And the court said there, just to quote, was that the true scale of losses for which liability might arise were of such significance that even the Crown should not be cast in the role of indemnifier. If liability of this magnitude was to be contemplated for biosecurity hazards, it would be better if it were introduced by legislation in which its metes and bounds might be thoroughly examined and laid down. Now, so the point being made by the New Zealand Court of Appeal here is, should NAF potentially be liable in respect of the import of anything posing risk of some kind? Whatever the consequences, I mean, the potential here clearly is pretty dramatic. I mean, for example, the losses in the case of a large-scale foot and mouth disease incursion into New Zealand have been estimated at $16.2 billion. So the rejection of the claim illustrates the concern of the courts not to open the floodgates to an indeterminate liability, and recognises that some liability matters can only be determined by Parliament. Incidentally, Strathboss did seek to appeal, and the case was settled just before it reached the New Zealand Supreme Court for the sum of $40 million. So it's settled for about 10% of the actual claim in that case, though of course that says nothing about the potential in other cases. Okay, so there we are. Those are three examples of claims needing resolution one way or another by way of the law of torts. And I think, as you can imagine, there are no limits to the nature and complexity of the questions with which the law has to deal. Now, I will finish with a slide depicting what we can call the snail in the bottle case. Now, this is the case of Donoghue and Stevenson. It comes from Scotland. One day, Mrs. Donoghue went to Well Meadow Cafe in Glasgow, where she drank a glass of ginger beer. She then poured a second helping of the ginger beer and out plopped the decomposed remains of a snail. Mrs. Donoghue sued the manufacturer of the bottle of ginger beer for making her sick. No, there's no direct connection between her and the manufacturer. And she won in the House of Lords, which was then the UK's highest court. Now, this case forms the foundation of the modern law of negligence. It is the absolute core decision. I have, in fact, written a book of songs called Leading Cases in Song, based on entertaining decisions of the courts. And this book includes a short opera based on Donoghue and Stevenson. And that also, I should say, is where the cartoon comes from. Well, I hope you've enjoyed this short introduction to the law of torts.